Hi guys! Welcome to another episode of Attorney Joe Vlogger, Law for the Everyday Layman. Today we're going to talk about annulment versus declaration of nullity of marriage versus legal separation. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Now, please take note that unless otherwise stated, the things that I will be discussing today are simply what the Philippine law says on the matter at the time of this recording. Of course, it may change as the laws get amended or new laws get created. And the point is, I am not expressing my personal opinions on the matter. This is simply what the law says at the time of this recording. Now, a like on this video or any of my other videos would also be highly appreciated. Okay, so now let's begin with our discussion. Under Philippine law as it stands today, there are only 3 civil remedies that will allow a husband and a wife to separate, namely annulment, declaration of nullity of marriage, and legal separation. As of the making of this episode, the divorce bill is not yet a law and therefore cannot be used yet. Okay? So we do not have divorce in the Philippines. Now, these 3 remedies that I mentioned that we will talk about today, they are different from each other. And they are civil remedies, which are different, of course, from criminal remedies, which provide for imprisonment like adultery, concubinage, we also have bigamy, and we also have VAUC, or the Violence Against Women and Children Act. Okay? Maybe I can talk about those in a separate episode, but for today, we'll talk about the civil remedies for a husband and wife to legally separate. Okay? Now, let's begin with marriage, which the law defines as a special contract of permanent union between a man and a woman entered into in accordance with law for the establishment of conjugal and family life. For a marriage to exist, both the essential and formal requisites provided for in the law must be present. And what are these requisites, no? The essential requisites of marriage are legal capacity of the contracting parties, who must be a male and female, and consent freely given in the presence of a solemnizing officer. On the other hand, we also have the formal requisites, which are authority of the solemnizing officer, a valid marriage license, and a marriage ceremony, which takes place with the appearance of the contracting parties before the solemnizing officer, and the personal declaration, personal declaration that they take each other as husband and wife in the presence of not less than 2 witnesses of legal age. Now, if any of these requisites are absent, they do not exist, then the marriage is void. Okay? When we say void, it is as if the marriage never existed. But if any of the essential or formal elements are present but there is just a defect, or an irregularity, then the marriage will still be valid. The only effect is that the party responsible for the irregularity may be held civilly, criminally, or administratively liable. Now, let's differentiate the remedies. In the Philippines, people commonly refer to the remedy with the catch-all term annulment. Okay? When the person wants to separate from their spouse, they approach a lawyer and say, "Attorney, papa-annul ako." Okay? But that's not technically correct. Okay? Because as I said, the remedies are different and the word annulment has a specific meaning and refers to specific cases. Okay? Annulment, as it is known, refers to marriages which are voidable, meaning that these marriages are valid until they are annulled by the court. Okay? They exist, they are correct, they are valid until they are annulled by the court. And since the marriage is valid until the point of annulment, that marriage produces certain legal effects before the point that the court says that, hey, it's annulled already. And after the court has annulled the marriage, the parties can now remarry. Okay? Annulment is different from declaration of nullity of marriage, in which the marriage is declared to be null and void. Okay? And this has reference to void marriages. And void marriages are those marriages which are inexistent from the very beginning. They never existed at all. Okay? They are inexistent from the very beginning. Why? Because even if the parties supposedly get married, the reality is, because of a certain ground, it will be as if the marriage never existed. And since the marriage never existed, it never produced legal effect. Of course, subject to the exceptions provided for by law. And after the court declares the marriage void, after compliance with certain requirements like recording of the decree, etc., then the parties can remarry. Okay, they can marry again. Finally, we have legal separation, which is only separation from bed and board, meaning physical separation. The husband can live separately from the wife. Okay? But the parties, the husband and the wife, they still remain married even if they now can live legally apart. Okay? In other words, even if the court declares that the parties are now legally separated, the marriage bond continues to exist. And therefore, the parties cannot remarry. Okay? Do you get it? They live separately but they are still married. Because they are still married, they cannot remarry. Otherwise, if they remarry, they may be liable for bigamy. Okay? Which is a criminal offense, which carries with it a penalty of imprisonment. Okay? That said, why would anyone choose legal separation? Because the obvious benefit for the innocent spouse, at least, meaning the one who did not give cause for the legal separation, is that the court may order the guilty spouse to pay the innocent spouse support. Okay? For the innocent spouse and for the children in the spouse's custody. Okay? So, that's the benefit of choosing legal separation. Now, let's talk about the grounds for each remedy. Okay? Meaning, what happened between the husband and the wife? And what is the correct case to file before the courts? Okay? At this point, I will say, leave it to your lawyers. Because what I will be discussing will be just for educational purposes. Okay? Now, let's begin with void marriages. Under the law, the following are void marriages. Okay? First, those contracted by any party below 18 years of age, even with the consent of parents or guardians. Okay? Why? Because they are a minor. Okay? You have to be legally capacitated. Okay? You must have legal capacity in order to get married. Second void marriage. Those marriages solemnized by any person who is not legally authorized to perform marriages. Okay? Unless, of course, the marriage was contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. So, who can solemnize marriages in the Philippines? First, any incumbent, meaning current member of the judiciary within the court's jurisdiction. If it's a judge, he's a judge of Manila, then only within Manila, or Parañaque, only within Parañaque. That the rule is different for Court of Appeals justices or Supreme Court justices, in which case it may cover the whole Philippines as the case may be. Okay? Who else can solemnize marriage, no? Any priest, rabbi, imam, or any minister of any church or religious sect who is duly authorized by his church and registered with the civil registrar, acting within the limits of his written authority. Okay? Provided that, okay, at least one of the contracting parties, no, at least one of the spouses to be, belongs to the church or religious sect. Okay? So, if you're gonna get married before, let's say, Iglesia ni Cristo, you have to be part of that religious group, no? Third person who can solemnize a marriage, any ship captain or airplane chief, but only for marriages at the point of death and while the plane is in flight or the ship is at sea or even during stopovers. Once the trip has ended, hindi na pwede. Only during the flight or voyage. Okay? Next, any military commander of a unit to which a chaplain is assigned and the chaplain is absent during a military operation, but only in the marriages at the point of death where one of them is about to die. Okay? Between persons within the zone of military operation, whether members of the armed forces or civilians. Okay? Another person who can solemnize marriage would be any consul general or vice consul in the case of marriages between Filipino citizens abroad. And finally, we have the city or municipal mayors. This is under the local government code. They have authority to solemnize a marriage. Take note that if the marriage is celebrated abroad and valid there, it will also be valid in the Philippines, even if the solemnizer is not one of those authorized by Philippine law. Next, void marriage. If the marriage is solemnized without a marriage license. Okay? If you have no marriage license, your marriage is void. Okay? Except there are exceptions, no? First exception, marriages at the point of death. Okay? You're about to die, you're gonna get a marriage license pa? Hindi na. Okay? Another exception under the law is if the residence of either party is so located that there is no means of transportation to enable such party to appear personally before the local civil registrar. Okay? Next, void marriage. Bigamous or polygamous marriages. Okay? Meaning, marriages which are contracted while another previous marriage is still validly subsisting or existing and not yet dissolved by the court. Okay? Let's say you're married now. You filed a petition for annulment, but it's not yet finished. Then you got married again. That's a bigamous marriage. You may be held liable for bigamy. Why? Because you have to wait for the judgment to become final and record it in the local civil registrar. Okay? Among others. Among other requirements. No? Now, there is an exception, which is if the prior spouse had been absent for 4 consecutive years and the present spouse has a well-founded belief that the absent spouse is already dead. But first, of course, there must be a judicial declaration of presumptive death. Okay, it has to be confirmed by the court. Another void marriage would be those contracted through mistake of one contracting party as to the physical identity of the other. Of course, you thought that that was the person you were marrying, and that is not actually the person, no? But it must refer to physical identity, okay? Not mistake in qualifications, etc. Okay, or you mistaken, you thought that that person was rich, no? And that's not a ground, okay? It has to be mistake in physical identity. Next, void marriage. Those subsequent marriages that are void for failure to obtain and record a judgment of annulment or absolute nullity of the marriage, partition and distribution of the properties of the spouses, and the delivery of the children's presumptive legitimes in the appropriate civil registry or registry of property as may be applicable. Okay? Again, I mentioned this earlier that if you're going to get married after or during the process of annulment, do not do that. Wait for the judgment to become final, record it in the civil registry, distribute the properties, distribute the presumptive legitimes, and after that, that's the only time you can validly remarry without incurring any civil or criminal liability. Okay? Next, void marriage. Incestuous marriages. Okay? Meaning, root word, incest. Okay? Or those between ascendants and descendants. Tatay sa anak. Or lolo sa apo. Okay? That is void marriage, no? Because it is incestuous. Those between ascendants and descendants of any degree. Okay? Or between brothers and sisters, whether of the full or half-blood. Okay? So, kahit half-blood lang yung relationship mo sa sister mo, yung step-bro, step-sis, void marriage yan. Okay? Now, next void marriage, no? Those void marriages by reason of public policy. And the law lists several, no? First, between collateral blood relatives, whether legitimate or illegitimate, up to the 4th civil degree. Okay? Kumbaga, marriage sa pinsan mo or first cousin, second cousin, ganon. Okay? But up to the 4th civil degree. Next, between step-parents and stepchildren. Next, between parents-in-law and children-in-law, void marriage. Okay? Another, between the adopting parent and the adopted child. Okay? You cannot marry your adopted child. Next, between the surviving spouse of the adopting parent and the adopted child. Okay? Yung naiwang asawa nung taong nag-adopt sa'yo, and if you are adopted, you cannot marry the surviving spouse. Next, between the surviving spouse of the adopted child and the adopter. Okay, that's a void marriage. Between an adopted child and a legitimate child of the adopter. And the next void marriage would be between the adopted children of the same adopter. Kasi parang magkakapatid na kayo. Okay? And one more marriage that is void under public policy would be between parties where one person with the intention to marry the other killed that other person's spouse or his or her own spouse, no? Okay? Para mapangasawa niya yung isa, pinatay niya yung asawa nung taong yon, or he killed his own spouse so he could marry that person. Okay? That's a void marriage. Next, there are more marriages, and some are not expressly enumerated under the law. Okay? Since the law defines marriage to be between a man and a woman, therefore, marriages between people of the same sex, man sa man, woman sa woman, are also void. Okay? This is because the Philippines, as of the time of this recording, does not yet have a law recognizing same-sex marriages. Okay? So, the remedy here is to file a bill, no? And pass it into law, allowing same-sex marriages. Okay? But as of now, marriages between the same sex are not recognized under the law and are therefore void. Okay? Next, marriages where the parties did not appear personally or did not give their consent in the presence of the solemnizing officer, like the priest, no? Such as marriages by proxy, by video conferencing, especially now at the time of the pandemic. You cannot get married by video conferencing under Philippine law because that will be a void marriage. Okay? Why? Because Philippine law requires personal declaration by the man and the woman that they take each other as husband and wife. And one more would be marriages where the parties merely signed a marriage contract without the presence of a solemnizing officer, where there is no marriage ceremony at all. Okay? Because the law requires a marriage ceremony with witnesses. Okay? The law does not require a grand ceremony, but it still requires a ceremony with at least the solemnizing officer, the parties in his presence, and witnesses. Okay? At least 2 of legal age. Finally, we have the void marriages by reason of psychological incapacity. And this is the most common ground used in the Philippines in case the husband and wife want to separate, no? Okay? Psychological incapacity refers to a mental, not physical, a mental incapacity of a party to make him or her unable to understand and comply with the essential obligations of marriage. Namely, that the husband and wife are obliged to live together, to observe mutual love, respect, and fidelity, and render mutual help and support. Okay? So this is the most common because as you will learn later on, some grounds have time limits. And baka pasaw na, okay, you're no longer within the time limit, the prescriptive period. So this is usually the ground resorted to by couples who want to separate, married couples who want to separate. Now, for the ground of psychological incapacity to prosper as ground for declaration of nullity of marriage, there are 3 requisites. First, gravity, meaning that the psychological illness must be grave or serious enough to bring about the disability of the party to assume the essential obligations of marriage. Let's say he has a psychological disorder that he cannot really understand that this is what he is supposed to do as a husband. Okay, that he is supposed to provide support or love, etc. Okay? Second, juridical antecedents. In other words, the psychological illness or whatever the cause is must be rooted in the history of the party and must be proven to be existing at the very least at the time of the marriage, even though the overt manifestations may emerge only after the marriage. Meaning, yung illness niya, yung mental disability niya, yung disorder niya, it should have existed before the parties got married. Okay? It should have existed at the very least at the time of marriage, even though the symptoms, the physical manifestations, only came out after the marriage. Okay? So you have to prove that. And third, incurability. Okay? It must be shown to be medically or clinically permanent or incurable, even only with regard to the spouse and not everyone of the same sex. Okay? So again, gravity, juridical antecedents, and incurability. So in all these cases, it is as if the marriage never existed and the marriage does not produce any effect. Therefore, generally I will give the exception later. Generally, children born during void marriages are now illegitimate because again, the marriage never existed. What about the property relations? The property relations of the spouses will be governed by either Article 147 of the Family Code, where the property of the spouses will either be governed by the rules on co-ownership and equal sharing, or under Article 148, where only the properties acquired by both the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. Okay? Article 147 applies to unions or marriages where the parties are legally capacitated, okay? And are not barred by any impediment to contract marriage, but whose marriage is declared void, such as in the case of psychological incapacity or a marriage without a marriage license. Article 148, on the other hand, which talks about actual contributions, applies to void marriages where the parties have capacity, the parties do not have capacity to marry, such as bigamous marriages, or one of the parties is a minor below 18, They do not have legal capacity to enter into a marriage. Okay? So while generally void marriages produce no effect, there are exceptions. First, in the case of marrying again before obtaining a judicial decree of nullity or annulment, and there is therefore liability for bigamy. Okay? So there is an effect. The second marriage will be recognized in order to prosecute you for bigamy. Second exception, in the case of psychological incapacity, children born during the marriage, even though it is declared void, will be legitimate. Okay? Those children are legitimate. And third, in case of marriages where the party concerned failed to obtain or record the judgment of annulment or nullity, partition, and delivery of presumptive legitimes, then the children in this case of void marriage will also be legitimate. And who can file a declaration of nullity of marriage? Of course, definitely the innocent spouse can file the case, no? But take note that a void marriage may be attacked collaterally, okay? Meaning that it can be attacked even by parties who are not the spouses, no? But there is a limitation. Only the compulsory or intestate heirs of the spouses can file. Take note also that an action to declare a marriage void does not prescribe, meaning there is no time limit. It can also be filed even after the death of one of the spouses, but again, only by the compulsory or intestate heirs of the spouses. Okay, to know who are the compulsory and intestate heirs, I have an episode on succession or inheritance law. Please just check that out, okay? Now we can move on to annulment. Okay, ito na yung hinihintay nyo, no? So, let's talk about annulment, which pertains to voidable marriages. As mentioned earlier, annulment is simply the general term by which laymen refer to the process of the husband and wife separating. Okay? However, this is not the true annulment, because the true annulment only applies to voidable marriages. As discussed earlier, voidable marriages are valid until they are annulled by the proper court of law. And the following are voidable marriages. Again, those which are valid until annulled, and these grounds must exist at the time of celebration of the marriage. No, first, that the party in whose behalf the annulment is sought was 18 years old or over but below 21. Okay, and the marriage was solemnized without the consent of the parents, guardian, or person having substitute parental authority. Okay, unless after attaining the age of 21, the injured party freely cohabited with the other, and they both lived together as husband and wife, in which case the marriage is ratified and now becomes valid. In other words, even if the marriage was voidable, it can still be cured. Okay? And for this case, if there is free cohabitation after the injured party becomes 21, then the defect is now cured. Okay? The marriage is now perfectly valid. Okay? Now, if you are going to file based on this ground, it can only be filed by either the injured party himself or herself, or their parent or guardian who did not give the consent. And it must be filed within 5 years after attaining the age of 21. Okay? The next voidable marriage would be where either party was of unsound mind, unless such party, after coming to reason, okay, freely cohabited with the other as husband and wife, in which case the marriage is ratified and becomes valid. Okay? So, in other words, the party is insane, no? Okay? However, was insane at the time or before the marriage, no? But it must be, it must happen at those times, no? However, the defect can be cured if after the insane party now regains reason, no, during a lucid interval, they continue to live with each other. Okay? And who can file the case? It can be filed by the same spouse who had no knowledge of the other's insanity, or by any relative or guardian or person having legal charge of the insane. And when will it be filed? At any time before the death of either party, or by the insane spouse during a lucid interval, or after regaining sanity. The next voidable marriage, no, would be that the consent of either party was obtained by fraud. Okay? May panlolokong naganap. Unless, of course, such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife, in which case the marriage is ratified and now becomes valid. Okay? Again, the defect of fraud, yung panloloko, can be cured. Okay? And the law also gives us some examples of fraud. No? First, non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. Another example, concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man who is not her husband. Another example of fraud, concealment of an STD, sexually transmissible disease, regardless of its nature, which was existing at the time of marriage, or concealment of drug addiction, habitual alcoholism, or homosexuality or lesbianism existing at the time of the marriage. Okay? These are grounds that constitute fraud which will render a marriage voidable. Okay? And if this is the ground, the case can be filed by the injured party within 5 years after discovery of the fraud. Next, that the consent of either party was obtained by force, pinilit kang magpakasal, intimidation, tinakot ka, or undue influence. Let's say he is a person who holds moral authority over you, and he convinced you to marry him. Okay? So that's another ground. Your consent was obtained by force, intimidation, or undue influence. Okay, but again, this defect can be cured. Okay, in case the force, intimidation, or undue influences ceases, no, it stops, and then the party who was forced or intimidated freely cohabits or lives with the other. Okay, and they live together as husband and wife, in which case the marriage is now ratified and becomes valid. Okay? If this is the ground that is going to be used, then it should be filed by the injured party within 5 years from the time that the force, intimidation, or undue influence disappeared or ended. Okay? Next ground for voidable marriages, no? That either party was physically incapable of consummating the marriage. Okay, with the other, there's a case in the Supreme Court because the penis of the man was too small, they could not consummate the marriage. Okay, so you're unable to consummate the marriage, to have sexual intercourse. Okay, and the further requirement is that the physical incapacity must be continuous and appear to be incurable. Okay. And if this is the ground, this can be filed by the injured party within 5 years after the marriage. Okay? And the last ground to have the marriage annulled, okay, would be if either party was afflicted with a sexually transmissible disease which is found to be serious and appears to be incurable. Okay? And this can be filed only by the injured party within 5 years after the marriage. So, as you can see, there are time limits for most of the grounds for annulment. That's why in practice, the most commonly used remedy is declaration of nullity of marriage on the ground of psychological incapacity, especially since it would seem that among all the grounds, this would be the easiest to prove. Okay? Especially if none of the other grounds really fit your case, no? But of course, if your situation falls exactly under any of the grounds and within the time limit, then it may be better to file the appropriate case. It will depend, of course, on the legal strategy of the lawyer and the desired result of the client. Now, unlike void marriages, the only parties who can file a case for annulment is the injured spouse, or in the case of a minor, the parent or the guardian. And unlike void marriages, which can be declared void at any time even after the death of one of the spouses, in the case of voidable marriages, they can only be annulled during the lifetime of the spouses. Kailangan buhay pa sila. Now, as I mentioned earlier, voidable marriages continue to exist and are valid until they are annulled by the court. And as such, these marriages produce legal effects while they are still valid. Namely, the children who are born before the judgment of annulment becomes final, these children are legitimate. and the property relations of the spouses during the marriage shall remain to be absolute community of property or ACP, or conjugal partnership of gains or CPG, as the case may be. Okay? ACP, yung absolute community of property, that's the default property regime if the parties were married after 1987, which is the effectivity date of the family code, and there is no prenuptial agreement. Okay? ACP consists of all the property owned by the spouses at the time of the celebration of the marriage, or which is acquired after the marriage, but does not include property acquired during the marriage by gratuitous title, meaning donation, no, or succession, no, by either spouse, or it does not include property for personal and exclusive use. Toothbrush, para sa akin lang yan. Okay? Or property acquired before the marriage by either spouse who has legitimate descendants by a former marriage. Okay? That's for ACP. But for CPG, that is the default property relation if married before 1987 and there is no prenuptial agreement. Under CPG, the husband and the wife place in a common fund the proceeds, products, fruits, and income from their separate properties and those acquired by either or both spouses through their efforts or by chance. Okay? Upon dissolution of the marriage or the partnership, the net gains or the benefits obtained by either or both spouses shall be divided equally between them unless otherwise agreed upon in the marriage settlements. Okay? Here, the spouses retain the ownership, possession, administration, and enjoyment of their exclusive properties, which are, first, that which is brought into the marriage as his or her own. Second, that which each of the spouses acquires during the marriage by gratuitous title, meaning donation or mana. Okay, third, that which is acquired by right of redemption, by barter, or by exchange with property belonging to only one of the spouses, and that which is purchased with the exclusive money of the wife or the husband. Now, after the marriage is annulled for any of the grounds for voidable marriages that I mentioned earlier, then the ACP or the CPG, as the case may be, will be dissolved and liquidated. Meaning, in general, there will be an inventory, then there will be payment of debts from the common property, and in case it is insufficient, they will be paid from the exclusive property of the spouses. And if there is anything left, then it will be delivered to the owner. Okay? Also, the presumptive legitimes of the children must be delivered to the children, no? And the net remainder, if anything else remains, now that will be divided equally between the spouses. Okay? That's in general. For the specifics, it will be best if you just let your lawyer handle that. Okay? However, take note that if either spouse contracted the marriage in bad faith, no? Okay? May malice, no? Or there is evident bad faith, no? Then his or her share in the net profits will be forfeited in favor of the common children. Okay? Meaning children ng husband and wife. If there are none, then the children of the guilty spouse from a previous marriage. And if none, then it will be forfeited in favor of the innocent spouse. And that order which I mentioned must be followed. Yun yung order. Okay? Now, if the marriage is annulled and the parties want to remarry, they can. But they must first obtain and record the judgment of annulment or of absolute nullity of the marriage, the partition and distribution of the properties, and delivery of the presumptive legitimes. Those should be recorded in the appropriate civil registry or registry of property. Now, finally, we can talk about legal separation, wherein the spouses are only physically and legally separated, but the marriage continues to exist. And therefore, the spouses cannot remarry unless they want to be prosecuted for bigamy. Okay? So, they cannot remarry. While some people may not prefer this remedy, there is an advantage here, no, to selecting this remedy, and that is the court may direct the guilty party to pay the innocent spouse support for the innocent spouse and the children under their custody. Okay? Now, another difference that legal separation has from void or voidable marriages is that the cause or the grounds must exist only after the marriage was celebrated. And what are the grounds for legal separation? No? First, repeated physical violence, okay, or grossly abusive conduct against the petitioner or the innocent spouse or a common child or a child of the petitioner. Okay? Physical violence or grossly abusive conduct. Second, physical violence or moral pressure to compel the petitioner to change religious or political affiliation. Okay? Let's say changing religion or changing political views, no? Third, attempt of respondent to corrupt or induce the petitioner, a common child, or a child of the petitioner to engage in prostitution or connivance in such corruption or inducement. Okay? The law does not even require actual prostitution, merely inducement, no? Hoy, mag-prosti ka, like that. Okay? That will be enough to file a petition for legal separation. Next, 4. Final judgment sentencing the respondent, no, the guilty spouse, to imprisonment of more than 6 years, even if he or she was pardoned. Okay? That will be enough to file legal separation. Next, drug addiction or habitual alcoholism of the respondent. That's a ground for legal separation. Next, lesbianism or homosexuality of the guilty spouse. Again, this is a ground for legal separation, and this is simply what the law says. The remedy, if you want to change this, is to create a new law. Okay? Next, contracting by the respondent of a subsequent bigamous marriage, whether in the Philippines or abroad. Okay? Next, sexual infidelity or perversion. Cheating, no? Cheating with another person or perversion, no? Next, attempt by the respondent against the life of the petitioner. Okay? Siyempre, papatay ka na. You should be allowed to legally separate, no? And last, abandonment by respondent without justifiable cause for more than 1 year. Iniwan ka ng more than 1 year. Kawawa ka naman. Mag-legally separate na kayo. Okay? Now, take note, no, that there are grounds for which a petition for legal separation may be denied. Okay? So, if the innocent spouse forgave the guilty spouse, denied ng petition. Okay? If the innocent spouse consented, okay? Consented meaning he gave it, the consent was given before the commission of any of those grounds, then the legal separation petition will be denied. Another is if there is connivance or agreement between the parties to commit the offense or the ground for legal separation, no? Next, if both parties have given ground for legal separation, edi parang quits lang kayo. Okay, so the petition will also be denied. Where there is collusion between the parties to win the case, no? They agreed, oy, you do this, I'll do this, then we'll win. Okay, that will result in the petition being denied. Okay, and one more, where the action is barred by prescription, meaning pasaw na, okay? The time limit is up. And the prescriptive period, no, is 5 years, meaning that the petition for legal separation must be filed within 5 years from the occurrence of the cause, okay? Otherwise, the petition will be denied, okay? Either 5 years from either the occurrence or discovery of the cause, as the case may be, okay? Now, in legal separation, there is what is known as a cooling off period, in which case, the case will not go to trial within 6 months from the time of the filing of the petition. Why? So that the spouses will be given a reasonable opportunity to reconcile. No? They might say, hey, mainit lang ulo ko noon, that's why I filed it, okay? Let's continue to live together, no? However, if the ground for the petition for legal separation is under Republic Act 9262 or the Violence Against Women and Children law, no, then there is no cooling off period. Trial will proceed immediately. Okay? Now, if the petition for legal separation is granted, then the spouses will have the right to live separately from each other. But again, the marriage still continues to exist. And since the marriage still exists, the children are still considered to be legitimate. As for the property relations, the ACP or the CPG, as the case may be, I discussed this earlier, the ACP or the CPG will be dissolved and liquidated. Okay, I also discussed that earlier. But the share of the guilty spouse in the net profits will be forfeited in favor of the common children, and if none, forfeited in favor of the children of the guilty spouse by a previous marriage. And if there is none, then it will be forfeited in favor of the innocent spouse. Again, in that order. Okay? And after that, the properties of the spouses will now be governed by a regime of complete separation of property. Further, the guilty spouse can no longer inherit from the innocent spouse, but the innocent spouse can still inherit from the offending spouse, ha? Siyempre, yung mabait, he can still inherit, no? Pero yung masama, wala na. Okay? So, if a will was made before the finality of the judgment of legal separation, the provisions in that will now be revoked in favor of the guilty spouse. But the innocent spouse can still inherit from the guilty spouse in the will. Okay? Now, even if there is already a judgment of legal separation, or even if the trial is still ongoing, the spouses may still reconcile. And if they reconcile, nagkabalikan sila, okay, and the proceedings are ongoing, then those proceedings should be terminated. Okay, it's useless to continue with legal separation, they're back together na. Okay? And if they reconciled after the judgment was rendered, then the effects of the judgment will be set aside, except that the property relation of complete separation of property will now govern, unless the parties agree to revive the ACP or CPG as the case may be. But in order for the reconciliation to take effect, the spouses must first file a joint manifestation under oath to be recognized by the court through a decree of reconciliation. If there is no decree, then the effects of legal separation will continue to exist. Okay, will take effect. As for custody, in all the cases I mentioned, whether for annulment, declaration of nullity of marriage, or for legal separation, it is the court that will be the one to determine when making the decision, no? When writing the decision, the court will determine who will have custody of the child, no? And the court will take into account several factors like the moral and material welfare of the child, the choice of the child, if the child is under 7, the preference is to be with the mother, okay? And other factors, no? And there are also exceptions. Maybe I'll talk about that in a different episode. But just for custody, just know that it is the court that will be the one to decide that in the same proceeding for annulment, declaration of nullity, or legal separation, okay? The paramount consideration for custody will be what is in the best interests of the child. Okay? So that's it for my discussion on annulment, declaration of nullity of marriage, and legal separation. Okay, I hope you may have picked up a thing or two, and I hope to see you again soon, guys. Okay? Bye!